Our guest today is Kate Smith-Thompson of KST Law. Kate, welcome to Probate Help Desk Podcast. And let's dive right into transfer on death deeds. What exactly is a transfer on death deed, and why should homeowners know about this?
Thanks, Reen, for having me back. I'm really appreciative to be on the podcast. A TODD or a transfer on death deed. Oh, and by the way, we're going to preface this once again by saying we're talking about Minnesota law, right?
Yeah, yep.
They exist in a number of states, and sometimes you might hear them called a ladybird deed.
Correct.
I know that in Florida they're called ladybird deed. In Texas they might be called that too. But essentially, a transfer on death deed is a deed or a document that goes and is recorded with your county recorder, and it sits on top of your warranty deed or the deed that conveyed your ownership of your property. And essentially, it says, I gift my property, or I'm transferring my property upon my death to a certain person.
Mm-hmm.
And it is a very powerful tool because it not only tells us who gets the house, it allows that person, a lot of um, really just interesting benefits and ways to protect themselves within in the estate process. It's also a wonderful tool for probate avoidance. So in common
Mm-hmm.
parlance, we call them TODDs in Minnesota. Sometimes again, ladybird deed, depending on where you are. But in Minnesota, it's a really great tool to help avoid probate and to really understand and direct where your real estate goes once you pass away.
Absolutely. And we do get a lot of questions from people about avoiding probate. And when you talk about avoiding probate, would this be a tool that the family would use before somebody passes away, or is it a tool that the family could use after
Yes.
someone has
So
passed?
a TOD is executed by the owner of a property. So
Hmm.
if you own a property, let's say you own a property in joint title with, the most common is of course a spousal situation, two people who are married to
Mm.
each other. You would execute a joint TOD, and or whoever owns the property has to, and a TOD actually has to be executed before somebody passes away. It's
Mm,
not something
okay.
you do after somebody passes away because it is intentions of ownership.
Sure.
So whoever owns the property would execute this TOD, record it with the county recorder, and then we know who gets the property. So yes, it is part of it's a tool that we use as part of the estate planning process. And it doesn't take effect until somebody passes away.
Hmm.
Now, something else that you should bear in mind, let's say you do have that joint property, right? We have a married couple who owns a property. If they execute a joint TOD and one of them passes away, nothing happens
Mm-hmm.
because those TODs for joint property are intended for, and I believe the exact wording is upon the death of the last of us or upon the
Okay.
death of both of us. So, let's say mom and dad have a house. They agree that oldest child is going to get the house. Um, Mom dies, dad still keeps the house. It's not like there's nothing's going to happen. They're not going to get booted out. Nothing
Hmm.
happens. Nothing happens with that TOD. And as a matter of fact, in that situation, we're going to probably look at revising that TOD,
Okay.
or we might be looking at just checking to see if something needs to happen or change in the meantime. So that leads me to one other thing
Hmm.
before you ask your next question. TODs are actually revocable, right? You can
Mm.
change them, you can revoke them. It's a document that can be changed. It's nothing is set in stone. It doesn't change ownership, but also if you change your mind about who gets the house, or
Yeah.
if something changes, you can absolutely revoke a TOD, and you can just send in a revocation to the recorder, they'll record it, and then all of a sudden it doesn't have any effect. Or you can just do another TOD and record that, and then that will supersede, or it will take the place of anything that was done beforehand.
Oh, very nice. So it
Okay.
sounds like there's a lot of flexibility with the Todd if you do it correctly.
Yeah,
Yeah.
they're a great tool. But there's a few things that everybody needs to know about them, which is one of the reasons why I feel like we needed to touch on this subject a little bit more in depth. They're
Hmm.
great tools, but I never, ever, ever recommend that anyone get into using a TOD lightly
Right. Right.
because they sound fantastic, and on a surface level they absolutely are. when you get into the weeds of things, they can be a little more complex. And that's another reason why it's just like anything else. Sure, you can record a TOD yourself. You don't need to use an attorney to do it. In most places, you can find a way to do it and just go down to the recorder and pay the fee and you're good. But if you don't know what you're doing, or if you're not sure, don't understand the pitfalls, and you don't understand the nuances that can happen when you have a transfer on death deed or a TOD,
Hmm.
right? You get yourself into the weeds, and then you may end up causing yourself more harm than you do good. So I
Absolutely.
always recommend that somebody see an attorney
Yep.
for assistance in preparing a TOD and filing it appropriately.
Absolutely. I make the same recommendation. Even if someone comes to me and they're looking at it as a real estate question, I prefer that they see an attorney because the attorney will often look at their entire situation and make sure that it's the right tool and it's being
Mhm.
used appropriately. And so, and it can save thousands and thousands of
Oh,
dollars.
absolutely.
So,
Tax benefits, but also, on the real estate side of things. Another thing to know about TODs, they go away if you sell the house.
okay.
So you as a realtor would be really, it's good for you to know this too. If there's a transfer on death deed on the house, let's say they decide they're going to sell the house and just go to assisted living, right?
Right. Yeah.
We're very common scenario. You as a realtor and your title and closing company don't need to worry if there's an active TOD on the house.
Oh,
Um,
nice.
the two things that you need to know is A, when you sell the property, if the
Hmm.
TOD hasn't been enacted, it goes away. It just
Nice.
goes away. Okay. It does not carry over. It's not like if when you sell the house and then 10 years later, mom and dad die and they go to the new owner and like, well, it's our property because mom and dad said we could have
Yep.
it. No, 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 they sold it.
Yep.
It goes away, right? So that's a piece to know. And then the other thing to know is selling and whatever. It doesn't create an insurable we'll talk about insurance in a minute, but as a realtor, if you see that if you see that in, or if a title company will see it, they won't worry a thing about it. It's just
Excellent.
not something you have to worry about. What you do need to worry about, though, is if somebody does sell the house and it's part of their estate plan, you
Hmm.
need to send them back to revise their estate plan because it's very possible that there was a deal struck amongst like children or siblings.
Yep.
X child gets the house, and then Y and Z children get more money because the
Mm-hmm.
house was part of the estate plan and this is supposed to be their inheritance.
Sure.
Right. Okay, now if the house is no longer an asset, we got to look at if we're trying to accomplish the same goals, we need to look at what that looks like. But
Got it.
that's after the transaction.
Absolutely. Let me take a step back. At the beginning of the conversation, you mentioned that a TOD is a great tool to avoid probate. Is that because I know in Minnesota and in many states there's a threshold for items that trigger probate, and a lot of times owning real estate, or in Minnesota owning real estate, is one of those things. So
Yeah.
by doing the transfer on death deed, that kind of takes the real estate out of the estate. And um, well, the question I was going to ask is, what are scenarios where the transfer on death deed helps somebody avoid probate?
First off, if you own the number one reason is if you own real estate in single title. Okay. If you have
Okay,
one
yeah,
owner. Okay.
yeah,
And that can look like a single person buying a property, or it can look like the second half of a married couple
mm,
where one has already passed.
okay,
Okay. Because a lot of time, one of the biggest things that happens, I see, we see half of a couple passes away.
yep,
And then, the house is the other, if they're in joint title, the house automatically goes to the other spouse. But you have to tell the county recorder
mm-hmm,
that the other person has passed away. So we have to file what we call an affidavit of identity and survivorship. And that takes that decedent's name off of the title. Now we have a property held in single title by one person.
right,
So now we need to execute a TOD to avoid probate because in Minnesota, ownership of real estate in single title
mm-hmm.
triggers probate.
There you go. Okay,
Okay.
yep,
So that's where the probate avoidance happens with a TOD. It affords you probate just means probing or questioning. The question before the court is who gets this stuff.
mm-hmm,
and the TOD answers the question, who gets my house?
Sure.
That's how it
Absolutely.
works.
And you mentioned that it's very useful in a situation where there's a single owner. What if there are multiple heirs or beneficiaries? Would a TOD be a tool you might use if there are multiple children that are going to inherit the
You
house?
could.
Yeah.
That gets interesting and a little complicated. And this is where
Okay.
TODs get a little in the weeds. And I'm really glad you brought this up. A TOD conveys ownership. It is not the same as willing a house to your kids. Very often, historically, you would say, I'm leaving the house to my kids in equal share. All
Right.
right. Well, before we get into the complexities of joint tenancy versus tenancy in common, and you need to understand how you own the house.
Mm-hmm.
But it used to be that everybody got, let's say there were three kids. Well, we had three shares, right? So everybody owned a third of the house.
Right.
And you can do that with a transfer on death deed, but it gets extraordinarily complicated because if you start naming beneficiaries on a transfer on death deed, and
Mm-hmm.
now all of a sudden maybe somebody predeceases you,
Oh,
maybe there's
yeah.
more than, if there's more than two
Mm-hmm.
beneficiaries on a transfer on death deed, things get really dicey.
Mm-hmm.
And I don't know many attorneys at all who will prepare a transfer on death deed for more than about two. I actually had a client, we had a transfer on death deed that we were dealing with where the transfer on death deed went to all four kids. And so each
Mm-hmm.
of them had 25%. And they were intent. Now, here's the good part, the family dynamic was extremely positive. They worked together. They all knew where
Mm-hmm.
each other stood. The intent was to sell the house. And at closing, because the way the TOD was executed, the kids were able to take title. They sold the house and they immediately split the proceeds because each of them owned 25% of the house. They
Mm-hmm.
each got equal parts at closing they were each paid
Right.
out,
Yep.
right? So, um, I don't know many attorneys and myself included. I won't do it for more than two beneficiaries, which
Okay.
is where the estate planning comes in. If you
Yes.
want, you can look at, if your house, like most middle class folks, if your house is your main asset, and when you go to sell it, that's where your inheritance is going to come from, or that's what you're going to leave for your kids. You can do a couple of different things. If you leave the house to one of your kids, um, I've heard people say, well, I'm just going to leave it to one of them.
Mm-hmm.
And I know they're just going to sell it and they'll split the money when they sell
Yeah.
it.
Yeah.
That is a leap of faith.
Yes.
And the other thing I will say is that that is not legally enforceable. You cannot write
Right.
it in your will that says, I'm going to TOD this to my daughter, and then she must sell it.
Mm-hmm.
It will not hold up. When you TOD a property to one person, that becomes their property, and they can do with it what they will. Once that deed is signed, it is theirs. There's nothing that anybody can do to control from the grave. There's nothing that you can put in a will that says they have to do one thing or another. They own that property. So what
Mm-hmm.
we do is often we'll say, okay, you've got the house. You want X kid to get the house. We talked about this a little
Yeah.
bit ago. But you've got life insurance. Okay, how much equity is this kid going to get in the house? you know, does the other one need more money? So maybe they get
Mm-hmm.
the house and then the other two split the funds, or,
Yep.
there's something that works out that way. But one of the things that you can do too is, and this is where you maybe would think about a TOD versus a trust. If you have more than a couple of kids, maybe consider putting your house in a trust and calling them equal beneficiaries so that
Sure.
when the house sells, it sells out of trust, and then the kids are paid out as beneficiaries of the trust.
And you mentioned estate planning and using the trust when there might be multiple kids.
Hmm.
Um, then are there scenarios where you as an attorney would recommend to your clients to use the TOD and transfer on death to the trust rather
Yeah,
than the,
you can
yeah,
absolutely do that.
yeah.
Yep, you can do a transfer on death to a trust. You can also do a testamentary trust, which would essentially empower your personal representative to convey the property to the trust
Mm,
on your death. But doing a TOD to a trust makes perfect sense because then that's then the trust actually owns it. And that's if you don't want to convey it, if you don't want to have a living trust or an inter
Mm.
vivos trust, if you want to use the Latin.
Yeah.
That's another great way to ensure that your kids each get an equal share. And if you have a complicated family dynamic or a blended family,
Yes.
yeah, and we've all seen them we've all seen those dynamics, either professionally or personally. Um, Consider doing a really robust estate plan
Hmm.
and really consider what you're going to do. Because the two things that are absolutely horrifying to do are to unintentionally have to go through probate because there's a problem or a question,
Yeah.
or to keep secrets.
Right.
And it's very hard for a lot of families when they go into, like, if you have a complicated dynamic. It's like grandma didn't want to tell us anything. We'll find out when she's dead. They read the will, they do the whole thing. That's Lifetime movie stuff, and it really doesn't have to happen in real life.
Hmm.
I'm much more concerned about everybody being on the same page, because not only do you have like financial stuff and you have family dynamics and you have emotions and you have history. Now, when you're dealing with, the loss of someone, you're dealing with grief, which
Right.
is just like the sprinkle on top of the sundae, right?
Yes.
So, and it just makes everything that much more complicated. So if you have an estate plan, if you have a game plan, and the TOD can be a part of that game plan,
Hmm.
so that everybody has a role, everybody knows what's going to happen, and nobody has really like can say, "Oh my gosh, we didn't know." No, 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 no. Have the conversation, have the tough talks now.
Absolutely. So you mentioned that TODs are very useful. They're useful to avoid probate. They're useful when there's a single person on
Mhm,
title. You mentioned that they're very useful if it's a smaller family or smaller group of children who
mhm.
would be inheriting the property. What are some of the other, are there other areas where a TOD is a great tool to use?
Yeah, actually, let's talk about taxes for just a minute. TODs are fantastic because um, when you receive a property through TOD, you actually receive a step up in basis.
Mm.
So, um, long story short, I don't know how many episodes you've had about how basis works and what capital gains is. So, capital gains tax is the tax you would pay on any kind of gain on a property sale,
Yep.
right? And I know you know all of this, but and for the most part, most middle class homes are going to be exempt because you're only gonna, I think there's a cap, or there's a
Hmm.
floor. You have to get a certain level of profit before you start incurring capital gains tax. Most people don't have to really worry about it,
Hmm.
but sometimes you do.
Right.
And where the way they calculate the capital gains is by taking the amount you sold it for minus the amount you bought it for and the
Mm.
difference there. Okay.
Hmm.
So when you ordinarily, if you're like, grandma's leaving me her house and her will, great.
Hmm.
You go through probate, you get a deed of distribution, and now all of a sudden you've inherited grandma's house. Well,
Yep.
grandma bought the house for $50,000
Yep. Yep.
and it's now worth 350,000. So now you automatically have $300,000 in capital gains. So that even if you sold that house tomorrow, now you're paying your capital gains tax on that difference.
Hmm.
With a transfer on death deed, you get a step up.
Oh, nice.
So
Nice.
let's say grandma leaves you her house via TOD, and now all of a sudden she dies and you take title at 350. Your basis is now 350.
Oh, very
If you
good.
sell it 10 years from now at 400, you're instead of that 300 here, you're only at 50,000 capital gains. So
That's
you've eliminated
fantastic.
your cash. So you get that step up in basis. And that is huge
That
when it
is
comes to that, especially when you have you know, title be staying in families and you have farmland, and yet it's a huge piece to be able to avoid that step up in basis, or to be able to get that step up in basis.
absolutely. What are some of the misconceptions or mistakes that you see people make when it comes to TODs?
The mistake, well, first off, using the wrong form.
Mm-hmm.
If you know, we've updated our forms, and we've had a lot of legal updates. We've had some legislative updates. There was a big one that happened last August, so about a year, little over a year ago. So it's currently September of 25. New law took effect August of 24.
Mm-hmm.
And one of the biggest conceptions is that we've fixed some of the questions regarding how we insure a property that has a TOD.
Mm-hmm.
And that's something that you need to be careful of. Another misconception is that, again, that you can control what happens to the TOD after you die.
Right.
You can't. We just talked about that. One of the other big misconceptions is that a TOD will shield you from a Medicare claim or a Medicaid claim.
Oh,
In
nice.
Minnesota, we call that MA.
Yep.
And we all know that, we all hear the trope, the nursing home's going to take the house.
Yeah.
An MA does not shield you from a Medicaid claim or an MA claim for recovery. Okay. So I am not an elder lawyer, and this is definitely, I know enough to be dangerous.
Mm-hmm.
But basically, the trope is that, you're going to apply for Medicaid because you don't have cash reserves to pay for your nursing home. And then the nursing home is going to go back to the county and bill your estate back for whatever they can recover or whatever
Right.
they're entitled to.
Yes.
And a TOD does not shield your property from that kind of claim.
Okay.
What it will do, you are allowed to, and you need a medical clearance certificate actually to
Correct.
do that. So if you have a Medicare claim or Medicaid claim or an MA claim in Minnesota, you may run into a little difficulty with that, and you're going to need to make sure that that's clear
Mm-hmm.
because when you go to sell the property, that claim may still be sitting out there, and they may
Right.
actually be able to place a lien and recover their assets when that house sells.
Yeah, and
So that's a big deal.
a lot of the title companies that we work with will require that certificate of clearance as well. And so
Mhm.
even if you don't think you need it,
Yeah,
it's
part of my probate practice, we have to do what we call notifying the commissioner.
mm-hmm.
And what that means is that we have to let the Commissioner of Health and Human Services for the state know that we are opening a probate. Sometimes they'll even file what's called a demand for notice with the
Mm-hmm.
court that says, we know this person's passed away. We have a nursing home claim. And we are going to collect on it, and we're going to file a claim with the probate court so that we can recover whatever assets we're entitled to. And so we notify the commissioner, and then I get a letter back that says, yes, there's a claim, or it says, no, we're not
Right.
seeing any history of any kind of claim. And being able to do that and then go back to the county and say, yep, we have no claim, we just need a medical clearance certificate, or be able to say, we're closing, we'll issue the medical clearance certificate once we know that we're going to be paid out at closing.
Absolutely. Absolutely. And I've worked in one case, I worked with an attorney on that certificate, and I can tell people watching, if you think this is something that you could do on your own or want to do on your own, going back and forth between the state and the county, every penny that you pay your attorney on this one is well worth it.
And one of the other things that people, and I don't want to get too far off the beaten path, but it's related. MA claims, especially if you've got limited equity, because we
Mhm.
have exemptions built in the law so that a spouse and children have certain exemptions. They're allowed to keep a certain amount of assets in the estate before bills are paid out. Okay.
Mhm.
And so those are exempt from claims. If your estate is what we call insolvent, right? We don't have a ton of money there, but the MA claim is going to eat the rest of it up, or it's only going to get paid a certain amount. You can actually, if you have an attorney and the attorney knows what they're doing, you can negotiate how much
Mhm.
you have to pay back on that claim, because you might be able to say, well, there are other needs in the family, there are other bills we have to attend to. It's a priority claim. It definitely takes priority, you know,
Right.
on the claim list, on the debts list. But you can negotiate it. And I've done that for families before, and it's well worth it. I'll say that. My
Absolutely.
fees are a percentage of
Yep.
what you can save on a well negotiated claim.
Highly recommend it. I highly recommend everybody take advantage of that for sure. Are there some other other misconceptions or mistakes that people associate with transfer on death deeds?
I think the other big one is that they assume the insurance will carry. So
Mm-hmm.
let's talk about insurance for just a second.
Sure.
That was a big deal last year in this new legislative update that we had. There was a court case called Strope Robinson versus State Farm, and this is again Minnesota specific. And long story short, there was a TOD, and the beneficiary, the grantor died, the beneficiary was preparing to take title, and somewhere in between there was a house fire.
Uh-huh.
And
Yeah.
it's a really interesting case. There's a whole lot more like juicy tidbits to go with it. But long story short, State Farm didn't want to cover the house fire because they said, well, this grantee beneficiary who's supposed to own the house, the insurance contract was between the guy who
Right.
died
Right.
and us. And
Yeah.
now the guy who died is there, and this person who was supposed to get title to the house isn't one of we doesn't have an insurable interest. We don't have a contract
Yeah.
with them. We're denying the claim. Well,
Yes.
of course they sued, and it was held up, but eventually State Farm was made to pay. I think they went to the state Supreme Court, and State Farm was made to pay some of the damages. Somehow that's the damages were had, but the legislature and well done for this. We had some legal advocates, and the legislature took up the question, and we clarified how insurance carries over, when
Mm-hmm.
it kicks in, and who is the insurable party, right?
Right. Right.
So what everybody needs to know is that if you have a TOD, there's certain guidelines you have to follow in order to make sure that that insurance kicks in and stays in place
Sure.
until whoever owns the house gets their own coverage. So
Yep.
the first thing you got to do is understand that a TOD insurance only carries over 30 days.
Mm-hmm.
So you can kick that. So, and actually that's 30 days from death.
Mm-hmm.
So it is very, very quick. So if you're a grantee benefit, and you should know that you're getting the house.
Right.
So let's say you're a grantee beneficiary, grandma dies, and she's giving you the house via TOD. Fantastic. Grandma dies, and it's really unfortunate. The very first thing you're going to do is get a copy of that death certificate and run to the agent's office and
Mm-hmm.
say, I need to renew, or I need to replace myself as the insured person, or I need to obtain coverage for this new house that I've just inherited or I've
Yep.
just been conveyed by TOD. Okay.
Yep.
The second thing they're going to do, and that has to happen within 30 days. If it's not, that house is uninsured until such time as you actually procure coverage and do it for yourself. And now that's the homeowner's insurance that's in place for the person who died, right?
Right. Right.
You
Right.
can, and eventually it'll be a new policy and you'll have to pay for the insurance yourself. The second thing that has to happen is, in order for those 30 days to happen, when you place a TOD on your property,
Mm-hmm.
whoever's doing the granting needs to inform their insurance company. And
Okay.
you have to do this, and it's the Wild West. Okay, Reed.
Yeah.
So here's
Yeah.
what's happening. We don't really know how there's no definition in the statute that says what constitutes notice, right?
Mm-hmm.
Because that's my first question as a lawyer. Well, what's notice? Does that mean I pick up the phone and I call my AmFam agent and I say, hey, I put a TOD on my house, and they go,
Yep.
great, click.
Right. Right.
Is that notice? We don't know. So another reason to use an attorney for these things is because we know how to make sure that there's a track, right?
Yeah.
So what
Absolutely.
we're going to do is we're going to send a letter, and we're going to inform the agent. We're going to call the agent. We're going to say, what constitutes notice and who do we need to talk to about this? And most of the time they'll say, well, just let us know.
Right.
Okay. Well, we're going to send a letter, and we're
Right.
probably going to send it certified mail. And we're
Yeah.
probably going to
Mm-hmm.
say, and we're probably going to include a copy of the recorded TOD. And we're going to say, you are thusly informed as an agent of,
Mm-hmm.
XYZ insurance company that we have a TOD on this property. And they're going to
Yeah.
go, great. And they're going to put a little note in the file, and it's going to go right into the filing cabinet, and then there it shall stay. But the notification is there, right?
Yeah.
Likewise, you can do an email with a timestamp and whatnot, or you can call your insurance agency and say, is there a portal I can upload this to? But you want to get some kind of receipt that proves that you notified. Okay.
Absolutely.
Yeah.
Absolutely.
And that has to happen. And then the other thing that everybody has to remember is that if you switch insurance companies, you
Mm-hmm.
got to re-notify.
Okay. Yeah.
If you and people shop their insurance all the time. If you're going to shop your insurance and you're going to get new, I mean, we all know homeowners insurance is just through the roof these days.
Right.
We're all shopping our insurance. Don't forget to re-notify your new carrier because otherwise
Absolutely.
that notifications, I mean, it does you no good if it's on your old policy. If
Abs-
that's the policy that's there when you need the TOD, that's the one that has to be notified. So you have to keep that on your list to do things, like age of roof, current
right.
thing, tax value, and oh yeah, let them know I have a TOD on there.
Yep.
Really, really important. Um, Another tactic that I've heard to extend that 30 days, and I don't know if it's actually works or not, but you could try it, is to add whoever your beneficiary is. So let's say grandma's leaving their house to grandson.
Mm. Mm-hmm.
Grandma should name grandson as an additional insured on the policy
Oh, very nice. Yep.
because then they have an insurable interest and that's been solidified and it's already there. Once again, I don't know if that actually does have the
Right.
practical effect that it should, and
Right.
that may come down to carrier.
Right.
So, above all, check with your insurance agent to find out what they need. And as we get moving on this, some of them will probably have a more formal process or maybe a notification form of some sort.
Mm-hmm.
I know a bunch of attorneys have worked up their own notification forms or their own information, ways to convey notice, but we're trying to formalize the process as much as we can.
That sounds fantastic. And it sounds like in this scenario that you described, it almost sounds like that if done correctly, the Todd would give them some extra protection that the estate or the beneficiaries wouldn't otherwise have when it comes to insurance. Because we run into that a lot. And you mentioned house burns down, but sometimes there's a squatter in there. Sometimes the squatter's a family member. Sometimes
Hmm.
people break in and steal the copper pipes out of the basement because the house is vacant. And then
Hmm.
the family finds out that they're not covered because the house is vacant and the and the estate is not insured unless they take out a vacancy policy, which a lot of people don't know about.
Yeah. So, and another advantage here, and I'll tell you this too. If you have a TOD, you can, as soon as you have the death certificate,
Mm-hmm.
you can, we have the way you could, so here, let's talk about how we redeem a TOD. Okay. So you've done your estate planning, grandma put the TOD in grandson's house or something, house or name or something. Grandma
Mm-hmm.
passes away. Grandson says, great, I own the house now. Okay. Yes, but we
Mm-hmm.
would have to do what we call an affidavit of identity and survivorship. So we present the death certificate and an affidavit and probably a photo ID to the county recorder. It's a document. Once
Yep.
again, we prepare it and we notarize it. It gets recorded and that executes the TOD. So
Mm-hmm.
now that person is the legal owner and you can execute. It stands in the place of a warranty deed or, it's a conveyance deed.
Mm-hmm.
Okay. So you now own the house via the TOD.
Right.
Now what you want to do is maybe and then you get your insurance sorted out and you get all that other stuff. But that's how you execute that TOD.
Yep.
And there's no technically, I don't think there's a limit to redeeming the TOD,
Okay.
but I don't think it has to be done within a certain amount of time, but it should be done fairly quickly. If you're in a probate situation where, the house was willed to someone,
Mm-hmm.
it's going to take a little while. You're going to need an appraisal. It's going to sit vacant a lot more. It may sit vacant. It may sit there for a little while until we determine whether we're buying or selling or what we're doing.
Sure.
Um, but it eliminates a lot of that other question. Like we know who owns that house, and it's not
Absolutely.
in that probate limbo, which is
Um,
helpful.
and Kate, speaking of probate limbo, I saw this in one of our Facebook groups. A scenario where the decedent had left the house to one of their uh, siblings, or not sibling. I think it was one of their children. They left the house to a child in the will. So they had a will. They left the house to the child, and then later on they did a transfer on death deed, leaving the house to, or the transfer on death deed would convey title to a different child,
Good question.
which
Which one?
takes
Which
precedence in
one
a
takes precedence?
yeah, yeah.
That is that is a great question. And as a matter of fact, I just saw that. So like I've got my cheat sheet here and um essentially if the house is willed to someone in the will, but
Mm,
there's a transfer on death deed that is available. First off, you're going to probate court because there's a
mm-hmm.
conflict.
Yeah,
Um,
okay.
we're going to have to identify, um, there's a couple of things that are going to happen. And my gut instinct is that most of the time, the transfer on death deed, the TOD would prevail.
Okay.
Here's why I say that. First, we're going to look at when
Mm,
everything was executed. If the
mm-hmm.
will was executed in 2010, but the TOD was executed when TODs became available
Mm-hmm.
in 2020, whenever they came, I think 2015 or something. If there's a significant difference and the TOD came much later, my guess is that that is indication of testamentary intent and
Mm-hmm.
that's an updated intent. Okay, so
Yeah,
whichever one came last. Now, if you put a Todd in the house and then you decide something else in the will, that's a little hairier.
yeah.
But my other intent, my other uh gut instinct on that is to say if whichever one came later, but probably the Todd, it's very hard to invalidate a Todd
Mm-hmm.
because a Todd's a legal instrument. It has to be notarized. You can actually have an attorney in fact or somebody who has power of attorney execute a Todd for you, but it cannot change your testamentary intent.
Sure.
So, let's say you did a will. So in that situation, let's say you did a will, you were later uh, diagnosed with dementia. Um, and now all of a sudden your power, we want to avoid probate. Your attorney, in fact, wants to execute a Todd.
Yeah.
The person they should execute that Todd to is whoever the will says
Mm.
gets the,
Well,
they
that's
can't
true.
change that
Yeah,
because that changes testamentary intent and you can't do that. So you can't favor another person. The only way that that would work might be if whoever was supposed to get the house dies
sure.
and then you need to name somebody else. But in that situation, you're most likely going to head to probate court anyway.
Right.
So a Todd wouldn't really do you much good in that situation. But my inkling is that it's going to be a situational, but overall, I would say the Todd probably rules.
Okay. Excellent. And I have one more. I knew once we got into this topic, time would go by quickly.
Yeah, of
Uh,
course. It
but
always does. I didn't want to get too much in the weeds. I hope it was pretty.
no, no. The question that I've been really wanting to ask, what about a scenario where there is a reverse mortgage? And I don't know the order on this one. But for example, if someone takes out a reverse mortgage and then later they use a TOD because they want the home to go to their child. Um,
Um, that's a really great question. How are reverse mortgages actually treated without that? Like what normally happens with a reverse mortgage?
my understanding is that the reverse mortgage, once the equity is gone, that the company that gave out the money would be entitled to that property.
Okay.
But
So
sometimes they have I also think they also have language in there that they might get it at a later date or when the person passes. I'm not sure when they get the property, but they are entitled to the property as far as I know.
yeah. Um a reverse mortgage is one of those things that I know in Minnesota they're very limited. And actually I
Mm-hmm.
think we have a different name for them and I cannot remember what that is, but I've heard that before. I think so here, yeah, in general with a Todd, you
Mm-hmm.
get the house, but you actually have to, it doesn't dismiss there's another
Yeah,
misconception. It
yeah.
also doesn't dismiss the mortgage.
You made me just think of that topic too.
Yeah. So I just thought about, the M&A claims and no, that's a great thing. If you pass away with a mortgage and you Todd your house, it deeds the house to that person. But what happens with your mortgage is entirely up to your mortgage contract. It comes down
Mm-hmm.
to what product you're in, who your lender
Right,
is. There's no universal anything.
right.
And what I've seen most commonly is that someone will inherit the house, and I'd say the vast majority of them are free and clear.
Mm-hmm.
But when there is a mortgage or a home equity line of credit or some other kind of encumbrance, it carries. The
Yeah.
deed the TOD does not excuse them. So what often happens with a mortgage company is if it's a, they may allow an assumption, they may allow them
Mm-hmm.
to assume the house
Yeah.
or assume the mortgage and continue paying it. Or they may call the mortgage and they may say, no, we need to be paid off because
Right.
we no longer have an interest in that property because our borrower has passed. Most often what people will end up doing is refinancing.
Right. Right. Yep.
And um really it's actually a favorable refinance because you only have to refinance what's owed on the house.
Correct.
So again, if you have a $300,000 house and they only owe 50,000 on it, you can take a small mortgage, pay off the old one, create a new
Mm-hmm.
mortgage for yourself, and now you have a very small payment. Likewise, you can pay it off, you can do or they can call the mortgage, you can just pay it off and then you own it.
Right.
With a reverse mortgage, my inkling is to say that they probably have priority.
Mm-hmm.
I have never actually seen a reverse mortgage with a Todd situation. That would
Correct.
make for a really interesting legal problem.
Well, maybe
So
I'll have one of those for you in the not too distant future. I know.
I'll have to look, but again, I feel like once again, I think the general knowledge would prevail there,
Yeah.
meaning if you it comes down to the terms of that contract. It's going to come down to the terms of that reverse mortgage or the terms from that lender or borrower, right?
Yeah.
So I feel like that's mostly, where the law stops and where the contract begins is kind of where that is. The only way you'd get around it or get out of it might be if there's something in that contract that is either illegal or needs to be challenged or
Mm-hmm.
litigated.
Yeah. The party that I'm thinking of, they watch this YouTube channel, and they reached out to me maybe about a month ago with they wanted to do some estate planning and they wanted
Uh-huh.
some advice. And but I know for a fact that the person who lives in the house does have a reverse mortgage on that property. And my first thought was, by the time this house comes to you, you might owe a lot of money on this property, or there might for sure the equity will be gone.
Yeah.
But that would maybe we'll talk more about that one. I'll have this person give you a call and we can figure
Yeah,
out
I'd
what to
love it.
do.
Send them my way. And
Yeah.
and even if that's the case, Reen, I love getting on. One of the things I'll say, and I'll throw this out there to anybody who is a real estate agent, a financial advisor. If you have somebody who you want to talk to a lawyer and they're not sure about it, find somebody like myself or
Mhm.
another one of my wonderful colleagues who will do a 30-minute consultation. I do those free of charge, actually. I do anywhere from 15 to 30 minutes free of charge, especially if it comes from a referral source.
Sure.
I'm more than happy to hop on a Zoom with all three of you. And as long as the client's okay with with you being in the room, um, a lot of times it comes from uncertainty and having
Right.
somebody there who's already proven to be a guiding source or a good counselor, um, that's helpful. So yeah, I'm absolutely willing to do that. And I love good questions like that because it makes me research and
Yes,
I
absolutely.
get to geek out over what I do.
I like
And
those
that's
too.
so much fun.
I like those
Why
too,
I do what
except
I do.
yeah,
I love new stuff.
absolutely.
Yeah.
Um, okay, we are almost out of time and we've covered a lot. Before I ask you for parting thoughts, let's just recap the process. So, or let's recap. So with the Todd, it's a great tool. It can help people in Minnesota avoid probate. We definitely want to make sure they're done properly. So spend some time, have either do it with an attorney, or is it also fair to have an attorney review the paperwork? Or
Absolutely.
yeah,
Yeah, if you want to do it yourself, pay somebody for an hour of their time to review it
yeah.
and to help you file.
Sure. And so it sounds like the process is person would fill out a form. Is it a county form typically in Minnesota that they fill out?
So if you wanted to use a transfer on death deed, we have what's called these uniform conveyancing blanks,
Mm,
and you can
mm-hmm.
actually look them up. I think they're on the Minnesota website. They're on the state website. I think it's either the I think the Department of Commerce has them.
Okay.
But if you Google Minnesota uniform conveyancing blanks, there's a state website that just pops up and you can find them. You need to use the correct form. So
Yeah.
if you own in single title, You can use that one. If you own a joint title, you need to use that one.
Mm-hmm.
Yeah, and then they fill out the form. You
Yeah.
have it reviewed by a lawyer,
Mm-hmm.
notarize it, get it signed and notarized, and then it gets filed with your county recorder. It gets
Yep.
recorded. Also,
And when you say it gets recorded, it's recorded with the recorder, but it's not activated until you come back and present the death certificate.
it sits on top of the deed.
Oh, it
So
sits
it
on
sits
top.
out there.
Okay.
It's active. It's absolutely, I mean, when it's recorded, it's active. But
Okay.
nothing happens. You don't create an insurable interest and you don't create an interest in the legal interest in the property or an ownership interest
Right, right.
until you redeem it.
Oh, redeem it. Okay.
Yeah.
Perfect. Perfect. And that's nice for the person who's conveying title on the property because they still maintain ownership of that property as
Hmm.
well.
Yeah.
Excellent.
So then you file it and then notify your insurance
Mm-hmm.
in whatever way you need to. And then you do nothing unless you feel like you need to revise it or you sell your property or, then we need to redeem it.
Sure.
One other thing, when you're doing your transfer on death deed, and this is again one of the reasons why you would really want an attorney to do this, you need to use the actual official legal description.
Mm-hmm.
And in Minnesota, you need to know whether or not you have abstract property or Torrens property,
Yes.
because we have two different property recording systems in Minnesota. And there's no telling which one you have unless you know exactly what's on your deed. And this is yet another reason to either use a title company or use an attorney because we can get that
Mm-hmm.
information for you and we can record it properly. The
Yep.
county recorders are very particular, and there's a whole different set of rules for abstract versus torrens.
Yep.
So you really need to know what you're doing when you record because it's a possibility you could have stuff rejected from the recorder. I have fought with a couple of different county recorders, and each recorder does things differently.
Mm-hmm.
It can be a little bit hairy at times. So having the guidance of somebody who's local, or who has walked through those situations before and maybe knows the path a little bit can be well worth your time, and it avoids a lot of headache.
Well, I think that I
And
had, oh, I'm sorry, go ahead.
I was just gonna say, and by the way, if you don't know the difference between abstract and torrens, hire a lawyer because we can do.
Yes.
And the legal description is not necessarily what's on your property tax statement. It's what's on your deed.
Mm-hmm.
So if you don't know if you need to find that, because you need to have the exact right description. It's not just what's on your property. What's on your property tax statement is usually like an abbreviated description,
Right.
and it's not your address.
Yeah. And Kate, I had a client one time. The other reason I highly recommend work with an attorney on this, I had a client once who wanted to sell the property and they came and they had all their paperwork, but the problem they ran into is they had their TODD paperwork notarized, but they never recorded it with the recorder's office. And so they essentially had nothing at that point.
Mm.
And just,
So,
a conversation with an attorney who understood the process and how to make sure it was properly recorded would have saved them thousands of dollars.
yeah. So, recording is a big thing. And, if the real property, it's like, it has to be, it used to be that if a TOD was recorded before the death of the grantor owner, it was valid. However, if it was registered like it was Torrens and the
Mm-hmm.
TOD was recorded only in abstract, the TOD was void. So
Mm-hmm.
you have to know which situation you're in. But yeah, if it's not recorded, it can go to testamentary intent,
Right.
but you can't record it after a death.
Right. Didn't help them avoid probate in that scenario.
Nope. Nope. You're gonna end up, and it could go to testamentary intent. It could say, well, we have this notarized. We obviously
Mm-hmm.
great. We know what they wanted to have happen.
Right.
So when we go through probate, we can say, great,
Yep.
we'll honor that choice. But
Yes.
again, you're going through probate and you have to do a deed of distribution and you're gonna have to follow those things. You don't get to take the nice little Todd shortcut.
That's exactly what happened.
Yep.
That's exactly
Nice
what happened.
thought, but it didn't work.
Correct. Uh, Kate, this has been so informative. Are there any other tips related to TODs that you would like our viewers to know?
I'd like everybody to know that lawyers are here to help. We don't bite. You can do a TOD at any given time. It does not have to, it can be part of estate planning, but it doesn't have to be in totally. You can change, they're flexible because you can change them, you can revoke them at any time you want. And that you can use them. They're very effective at knocking down one of the most common probate triggers that you have, which is ownership of real estate. We all want to be homeowners. We all want to, live that's part and parcel. That's part of that building block of the American dream and generational wealth. And we all know what comes with homeownership. This is a huge part of responsibility and about building that and leaving something of a legacy for those who you leave behind. So I strongly encourage everybody to look at this as a wonderful and flexible tool in
Hmm.
your estate planning toolbox.
Absolutely. Our guest today has been Kate Smith-Thompson of, uh, excuse me, our guest today has been Kate Smith-Thompson of KST Law. And Kate, how can people get a hold of you?
The best way to reach me is via email, and my email is kate@kstlawmn.com. You can also find me on Facebook under KST Law, Instagram at KST Law MN, and you can find me online at www.kstlawmn.com. And also, Reen, if I can, I'd like to throw a quick little plug. I'm going to have an Ask a Probate Attorney Facebook Live, and that will be on October 3rd,
Yeah.
uh, second or third, I think. And actually, we'll have the information hopefully in the caption below once this is published.
And Kate, if that becomes an ongoing event, are you going to share updates on your website? If so,
Absolutely.
yeah. So if
Absolutely.
people miss this one, but they're watching in the future and they want to join one of those calls, they can
Yeah,
get the
absolutely.
information on the next one.
We'll be doing Q&A. We'll be doing Minnesota specific because
Hmm.
I can't speak to anything else. We'll talk about some general things, but we will be doing some Minnesota specific Q&A. I'll be open to taking Q&A from the audience on probate matters from Minnesota, and it will be recorded. So if anybody
Perfect.
wants to catch back up later, they totally can. And likewise, if anyone has a question for me that they'd like me to answer, and they may not either be able to make the webinar or they just want to have something ahead, feel free to email me or to shoot me a message on Facebook under my KST Law Facebook page, and I'll be more than happy to address whatever is on anyone's mind.
Perfect. Well, Kate Smith-Thompson, thank you so much for joining us today. It was a pleasure, and we look forward to having you back again.
Thanks, Reen. You have a great day.